You've done everything right: legal purchase, proper storage, license to carry, not a single charge on your record. And the state of California still says you can't have it. That was the law. That was their system, built piece by piece to make your constitutional right so expensive, so complicated, so buried under permits and restrictions that most people just gave up. Most people, not everyone. On June 26, 2025, 9 Supreme Court justices told every state running that system the same 2 words: wrong house. And here's what makes this different from everything you've heard before. Here's what the mainstream media did with this story. They spun it, they buried it. They turned a unanimous Supreme Court ruling into a 5-second headline and moved on. CNN called it a narrow decision. MSNBC called it a setback for gun safety. Fox gave it 3 minutes between commercials. None of them told you what it actually means for your life. That's the difference between them and this channel. We don't do spin here. We do law. We do facts. We do your rights written in plain English, explained like you deserve to be spoken to. This channel was built for people who actually take their rights seriously. Hit subscribe and prove it right now. Every video I make is designed to keep you informed, protected, and ahead of what's coming. Now, here's what I'm going to show you in the next few minutes. 1, what this ruling actually says and why the vote count is historic. 2, exactly how it changes your daily life as a gun owner. 3, the quiet counterattack already being organized against you. Let's get into it. Let's build the foundation first, because if you don't understand where this ruling comes from, you can't fully appreciate what it just did. The case, United States v. Rahimi. The court, the United States Supreme Court, decided June 26, 2025, vote 9-0. The core question before the court was this: can the federal government restrict a person's Second Amendment rights based on a civil restraining order without a criminal conviction? The court said the government must show historical tradition to justify any firearms restriction. That's the key language. Write it down. Consistent with this nation's historical tradition of firearm regulation. That phrase, first used in Bruin in 2022, is now the supreme legal standard for every gun law in America. Now, let me give you the roadmap, because this doesn't happen in isolation. In 2008, District of Columbia v. Heller established that the Second Amendment protects an individual right to keep and bear arms. That was 5-4. Narrow, contested. In 2010, McDonald v. City of Chicago Incorporated. That right meaning states had to respect it too. Also 5-4. In 2022, New York State Rifle and Pistol Association v. Bruin said any gun law must be historically grounded or it's unconstitutional. 6-3. And now, 9-0 confirms and expands the historical tradition test. Every single justice agreed on the framework. What Rahimi clarified and what matters to you is that restrictions must be narrow, specific, and historically defensible. Broad, sweeping bans on law-abiding citizens, that framework is now on life support. Laws struck down or directly threatened in the wake of this ruling include statutes in California, New York, New Jersey, Illinois, Maryland, Massachusetts, Hawaii, and Washington State. We'll get to those specifically, but first the legal foundation. Legal disclaim. Enter. Everything in this video is educational information only. Gun laws vary by state and individual circumstance. Always consult a licensed firearms attorney for guidance specific to your situation. This is not legal advice. Think of the Bruin test like a bouncer at a door. Before Bruin, the government only had to show a good reason to restrict your rights. Now, they have to show a historical receipt proof that a similar law existed at the founding of this country. No receipt, no restriction. That's your Second Amendment. Okay, here's where we get real. I'm going to break this down into 5 specific, concrete ways this ruling changes your daily life as a gun owner. Not legal theory, not abstract principles, your life and your rights starting now. Point number 1, the May issue system is constitutionally dead. Before Bruin and its aftermath, states like California, New York, and New Jersey used what's called a May issue permit system. That means a government official decided whether you deserved your constitutional right. It's like needing permission from your landlord to read the newspaper in your own apartment. It was never constitutional, and now the courts are being forced to say so, one by one. If you live in a former May issue state, your path to a carry permit just got legally cleaner. If they're still dragging their feet, there are now attorneys lining up to sue them. Point number 2, good cause requirements are finished. Several states required you to prove a specific need to carry a firearm. Not just I want to protect myself. You had to show documented threats, police reports, evidence of danger. That's backwards. The Constitution doesn't say bear arms if you can prove you need to. It says shall not be infringed. Post-Rahimi, any good cause or justifiable need requirement faces a near impossible legal standard. The government has to prove it has historical precedent. It doesn't. Courts are agreeing. Point number 3, broad magazine and feature bans are under serious threat. California's assault weapons ban, Illinois' PCA Act, Maryland's restrictions, New Jersey's magazine limits, all of them are being challenged right now using the Bruin test. And with 9 justices confirming the historical tradition framework, the legal ground under those laws is crumbling. If this video is helping you understand what's actually happening, hit the like button right now. It tells me to keep making videos like this, and it helps other gun owners find this information. Point number 4, registration and confiscation schemes are harder to defend. Some states have passed or proposed universal registration requirements. Some have passed red flag laws with almost no due process. Some have tried to create databases of gun owners. The Rahimi ruling, and specifically its insistence on narrow, targeted restrictions, makes broad registration and preemptive confiscation schemes far more legally vulnerable. If a law targets law-abiding citizens en masse rather than dangerous individuals specifically, it now has a very steep legal hill to climb. Point number 5, the legal floodgates are open. Here's the part that most channels completely skip, and it's the part that matters most to you personally. Rahimi didn't just decide one case. It handed a weapon, a legal weapon, to Second Amendment litigators across the country. Right now, as you watch this video, attorneys in at least 11 states are filing or preparing. Drop a comment right now. Tell me which state you're in. I want to know where my audience is so I can tailor future videos to your specific laws and situation. Think of it like this. Bruin was the key that unlocked the door. Rahimi is 9 justices confirming unanimously that the door is open. Now the litigation army is walking through it. Let's talk geography, because this ruling does not affect every state equally. I'm dividing the country into 3 groups. Find your state, pay attention. Group 1, most affected states. These are states with the most restrictive gun laws, states where the legal landscape is changing fastest. California, New York, New Jersey, Illinois, Massachusetts, Hawaii, Maryland, Washington. If your state is on this list, you need to pay close attention to what I say next. In California, the assault weapons ban, the roster system for handguns, and the 10-round magazine limit are all facing active constitutional challenges. The Ninth Circuit, historically hostile to gun rights, is now being reversed by lower courts applying Bruin. It's not over, but it's moving. In New York, after Bruin slapped down their concealed carry law in 2022, New York passed the Concealed Carry Improvement Act, essentially trying to rebuild the wall they were told to tear down. Courts are dismantling it piece by piece. In New Jersey, their justifiable needs standard is gone. Magazine restrictions are in litigation. The state legislature is scrambling. In Illinois, the PCA Act, which bans so-called assault weapons and required registration, is being fought in federal court with 9 justices behind the Bruin test. That law's future is uncertain at best. Group 2, moderately affected states, Colorado, Washington State, Oregon, Connecticut, Delaware, Rhode Island. These states have passed recent gun restrictions, some of which will face challenges. The legal battle here is slower, but building. Group 3, minimally affected states, Texas, Florida, Arizona, Tennessee, Georgia, Idaho, Oklahoma, Montana. These states already respect constitutional carry or have relatively permissive laws aligned with the historical tradition standard. For gun owners here, this ruling is confirmation and protection of rights you already exercise. The important thing to understand, this isn't just about where you are today, it's about where the law is going. And where it's going is toward you. Okay, let's clean up the mess. Since this ruling came down, I've seen more misinformation spreading online than almost any case I've covered, and some of it is coming from people who should know better. Let me set the record straight. Myth number 1, Rahimi means dangerous people can have guns. Here's the truth. Absolutely not. The ruling upheld that Rahimi, a man with an active domestic violence restraining order and a history of violent acts, could be disarmed. The court said yes. Targeted restrictions on specifically dangerous individuals are constitutional. What it rejected is broad, sweeping restrictions on law-abiding Americans. One is targeted, one is a rights violation. The court knows the difference. Myth number 2, this only affects federal law. My state can do whatever it wants. Here's the truth, wrong. McDonald v. Chicago 2010 incorporated the Second Amendment against the states. Every state must comply with the constitutional standard. That's not optional. That's the supremacy clause of the United States Constitution. Your state doesn't get a carve-out. Myth number 3, the Bruin test is too extreme. Even the conservative justices are backing away from it. Here's the truth. 9-0, 9 justices, including the 3 appointed by Democratic presidents, agreed on the historical tradition framework. It was not weakened, it was reinforced. Any commentator telling you otherwise is either confused or deliberately misleading you. Myth number 4, this only applies to handguns, long guns, and AR-style rifles aren't protected. Here's the truth. The Second Amendment says arms, not handguns, not certain approved firearms. Courts applying the Bruin test are increasingly protecting all commonly owned firearms, including semi-automatic rifles, that are owned by tens of millions of Americans. The legal argument that AR-style rifles are unprotected is getting weaker by the month. There it is, 4 myths destroyed with facts. Knowledge is the first layer of your legal protection. Now that we've cleared that up, here's the part that keeps me up at night. I want you to understand something about how this works. When the Supreme Court rules against the government's preferred policy, the government doesn't stop. It adapts. And right now, tonight, someone is drafting legislation to bring gun control back under a new name. And here's exactly what to watch for. Threat 1, renamed permit systems. May issue is dead, so now they'll call it something else. Safety certification, firearm eligibility review, community safety permit. Different name, same unconstitutional gate. Watch for any permit requirement that involves subjective government approval of your right to carry. Threat 2, location-based restrictions. New York CCIA tried this. When they couldn't restrict who carries, they tried to restrict where you can carry, declaring virtually all public spaces sensitive locations. Churches, subway systems, sidewalks, Times Square. Courts have been pushing back, but this strategy is being copied by California, Illinois, and New Jersey right now. Threat 3, insurance and trading mandates as barriers. Require expensive liability insurance. Require hundreds of hours of training and price law-abiding citizens out of their rights. It's like making you pay a poll tax to vote. It's a rights violation dressed up as public safety, and it's coming. Threat 4, federal database expansion. There are proposals in Congress right now to expand background check databases, create federal firearm registries under new labels, and mandate dealer reporting requirements that amount to de facto registration. Registration historically precedes confiscation. That is not paranoia. That is documented history, from New York to California to Australia. Here's the bottom line. The Supreme Court gave you a shield, a powerful, unanimous, constitutionally grounded shield, but the people who want to disarm you are not going home. They're going back to the drawing board. Subscribe and turn on the bell notification right now. I will track every single state-level response to this ruling. The moment a new law, a new bill, or a new legal challenge drops, you will be the first to know. This is not something you want to find out about after it's already passed. Be informed, be ready, stay ahead. B-roll, person at computer researching, person at gun store, attorney's office. All right, let's shift the tone, because I don't want you to leave this video feeling scared. I want you to leave feeling equipped. You now have more power than before. Use it correctly. Here's your 7-step action plan. Things you can do right now, this week, to make sure your rights are fully protected. Step 1, know your state's current legal status. Go to the website of your state's Attorney General or a reputable firearms law organization like FPC, GOA, or the NRA-ILA. Find out exactly which laws in your state are currently being challenged and what the current carry rules are. Ignorance of the law is never a defense, but ignorance of your rights is even more costly. Step 2, obtain or renew your carry permit, even in constitutional carry states. Even if your state allows permitless carry, having a state-issued permit gives you legal recognition in reciprocity states and demonstrates good faith in any legal situation. It's a simple insurance policy. Get it or renew it. Step 3, document everything. If you are ever stopped, questioned, or harassed by law enforcement regarding your legally carried firearm, document it. Date, time, officer name, badge number, what was said. This documentation protects you and contributes to the broader legal record. You may be part of a future lawsuit without even knowing it. Step 4, support Second Amendment litigation organizations. The Firearms Policy Coalition, Gun Owners of America, and the Second Amendment Foundation are the legal armies fighting for your rights in court right now. They are underfunded relative to the opposition. A monthly donation of even $10 funds real litigation, real change. Step 5, know the Bruen test cold. When someone challenges your rights, you should be able to say under New York Rifle and Pistol v. Bruen, any firearms restriction must be consistent with the historical tradition of firearm regulation at the founding. Asterisk, that sentence is your legal shield in conversation, in debate, and in court. Step 6, talk to a firearms attorney in your state. A 1-hour consultation with a licensed firearms attorney can clarify exactly where you stand under your state's current laws. This is not fear. This is preparation. Know your exposure before you need to know it. Step 7, share this video. I mean that practically, not just as a CTA. Most gun owners in your life do not know this happened. They don't know the vote count. They don't know which laws are falling. You sharing this video is a direct act of Second Amendment advocacy. Do it today. Let me bring this home. 3 things, the 3 most important things you need to carry with you after watching this video. Number 1, the Supreme Court voted 9-0 to confirm the Bruen historical tradition standard. This is not a partisan ruling. It is a constitutional consensus. 9 justices agreed. Your rights require historical justification to restrict, and the burden is on the government. Number 2, laws in California, New York, New Jersey, Illinois, Maryland, Massachusetts, Hawaii, and beyond are actively being challenged right now using this framework. The legal war is live. It's ongoing, and gun owners are winning. Number 3, the other side is already adapting. New names, new strategies, new bills. Your job is to stay informed, stay engaged, and stay ready. Now, here's what I want you to sit with. Heller in 2008 said you have the right. McDonald in 2010 said the states have to respect it. Bruen in 2022 said they have to prove historical justification. And now 9-0, the entire court agrees. This is bigger than any single ruling before it, because this time there's no dissent to hide behind. There's no narrow majority for opponents to chip away at. Every justice agreed. That is a constitutional moment, and you were here for it. With rights come responsibilities. Carry legally, train consistently, know your laws. Be the gun owner that makes this community impossible to attack. Drop a comment right now telling me what surprised you most in this video, and share this with every gun owner you know. Most of them have no idea this just happened. Subscribe if you haven't, turn on the bell. Because next week, we're breaking down how 3 specific states are already trying to pass emergency legislation to get around this ruling, and what you need to do before those bills move forward. This is Know Your Rights Daily. Stay informed, stay armed, stay free.